so we're here today with Shannon Morrissey. She's a associate at WilmerHale, and she does a lot of work in the spaces of disclosure rules and ESG disclosures. So we're really happy to have her on today to talk about the new federal rules as well as the California specific rules, because she's based here in San Francisco. So Shannon, great to have you here today.
Thanks so much for having me, Patrick.
So first, I just wanted to learn a little bit about yourself and your career path and what brought you to this space. So maybe you could tell me a little bit about how you got here.
Yeah, great question. So I am originally from Jacksonville, Florida, as I was just sharing with you, Patrick. And I went to college in Florida, but always since high school, so that feels like always, knew that I wanted to become an environmental attorney and move to California. So that
So you knew
career
throughout
path
undergrad that you wanted to be an attorney.
I did. Yeah, I was one of those rarer students, I suppose, that knew that as early as high school. So I know a lot of law students go to law school and know they want to be in law school and potentially be an attorney, but they don't know exactly what they want to do. But I knew before I got to law school, I was certain I wanted to be an environmental attorney. Essentially had, I think she was an AP biology teacher in high school, who was a hippie, which was new to me at the time, right? Like I distinctly remember she had earrings made of her teeth that had been pulled. So like very, what we would describe in Northern California as crunchy. This very crunchy, wonderful woman.
Crunchy in San Francisco where you are now. I mean.
Exactly. So it would fit in well here, but at the time in Northeast Florida, which is essentially South Georgia, the concept of environmentalism, not that it was so foreign, but it really was not mainstream in Florida yet at that time. Like we recycled, but that's kind of where it ended at the time, early 2000s.
So your teacher in high school really got you focused on environmental issues. So you always knew you wanted to be an environmental lawyer, and that was kind of your pathway through law school. You kind of focused on those issues. And then you become a young associate. And how were you able to guide yourself towards these environmental issues rather than getting stuck, defending insurance companies or, a lot of the different work we have to do along the way?
Yeah, so because I knew that I wanted to become an environmental attorney at the beginning and throughout law school, I really focused my extracurricular activities, including externships and internships and real world experience on environmental law. So I did an internship with the government at the State Water Resource Control Board, the California Attorney General's office, focused on environmental litigation. And then I landed a job at a law firm working in their environment and natural resources group. I was at a firm called Stoll Reeves before I moved to San Francisco and joined WilmerHale. But luckily, the entire time I have been working, I have been in an environmental practice group. So I haven't really had to mark my stake in the ground and say, I want to do environmental law, because I was working in an environmental group. So I've been really lucky, and I'm really grateful for that. And it's, I think, in part because I was so focused on doing this and gaining all the experience I could before I began working full time. But also really grateful that I've worked at law firms that have true environmental law practices, because some major law firms don't.
Yeah, absolutely. Or they're starting to, but it's still, they're behind the eight ball in a lot of senses. Or
exactly.
They're not exactly pushing it as strongly as they want. There might be a bit of marketing about it, but not necessarily the full force of the firm. So Tell me a little bit about the topics you're working on now. I know we talked about disclosure laws, but maybe I think our audience has a general understanding of what disclosure laws are, but if you could perhaps tell me a little bit about what you do day to day with a lot of the companies you're advising, and then we could talk specifically about the SEC rules, since they've just come into effect. Or they haven't come into effect, they've been authorized, but now stalled. So
Exactly. Yeah. Yeah. So my practice is more broad than only ESG issues and climate disclosure compliance, but I can start so more broadly. I have a good chunk of my practice is traditional environmental law. So think of the traditional environmental statutes, the Clean Water Act, the Clean Air Act, CERCLA, TSCA, and the list goes on, right, with the environmental statutory soup. But so that is a good piece of my practice. I do quite a bit of regulatory and compliance work, especially in California when new regulations come out to implement parts of statutes. There are constantly new regulations here. Recently, a client asked about the Clean Air Act waiver that was granted to California for mobile sources. Then there's also a clean fleets rule for trucks in California. So California does its own thing often enough and goes beyond the federal minimum legal requirements where the state's permitted to require more than the federal minimum. So I do a lot of advising on those sorts of topics, both at the federal and state level. The state tends to be pretty active, especially when we're in a Republican presidential administration. So we will see what November brings. But my practice under the Trump administration was more state focused, and my practice under the Biden administration is more federal focused. So regulatory and compliance work with both federal and state laws, as well as enforcement and defense work, that is quite a large part of my practice as well. And that typically stems from the traditional environmental laws, again, like Clean Water Act compliance, but there's an agency, the federal EPA, the state EPA, or other agencies enforcing against our clients. I sometimes dip my toes into litigation, but it usually stops with agency administration, agency administrative enforcement actions, and sometimes appeals. And then I also do a bit of transactional due diligence work when there's an environmental component of a deal, such as a waste company that owns a lot of land that may be contaminated. We help assess the risk there. And then finally, I would say the third largest piece of my practice is ESG and more policy related work. I look at this work as policy work right now, although there are now mandatory laws, so it's less theoretical and less policy, and now actual law, which I'm excited to talk about in a minute. But my ESG work is also pretty varied. The policy work, as I call it, is where we help companies do something as an internal policy or potentially external facing that's not required under the law yet. So for example, we have helped companies so these are voluntary projects that companies undertake for various reasons. Sometimes they're just do-gooder companies. Other times there's pressure from their consumers, their stakeholders. We've been involved in shareholder proposals that have directed or asked a company to do something. And then if there's a successful shareholder vote approving that proposal, the company must take action. So this is not required under law, but it's required by shareholders. So one example of that type of work is last year we were involved in a deforestation assessment for a major home retailer, and there was a successful shareholder proposal. And so we undertook the third-party assessment of the company's forestry practices, policies, wood sourcing. And although we didn't audit their wood sourcing itself, like we didn't audit exactly where the wood is coming from, there was a different department doing that. We assessed or audited the company's policies to ensure that no deforestation was occurring. We've also done environmental justice related audits. What impacts are the company's operations having on communities in which they operate? Those are both voluntary and requested by shareholders, but it's an interesting new area of the law, I think, for many companies, or new practice for those of us in this area, because it's not yet legally required. But environmental justice audits, for example, may very well be required in the future, and some form of an environmental justice assessment can be required when you're seeking a new permit for a facility in an area that is overburdened. And then we get to climate disclosure. So that's a huge part of my ESG practice as well, because there's been so much attention here.
Sounds like you have a really interesting practice. And so, yeah, I'd like to talk a bit more about the newly released SEC rules, if you like.
Yeah, and I know you had, I will spend some time in the SEC rules, and then I'm also going to spend some time on the California climate disclosure and financial climate risk reporting rules. So let me just start with SEC rules and level set on where we are at. Yeah. So before I talk about the substance of the rules, I want to just briefly give a rundown of the current status of where are we at with these rules. Are they in effect? The answer is no. So on April 4th, the most recent action is April 4th, which is just about a week and a half ago. The SEC, and the SEC is the agency that issued these climate-related disclosure rules. And I'll talk about that more in a minute, because it is funny to think about, like, why is the Securities and Exchange Commission regulating climate, right? So I'll talk about that in a second. But on April 4th, 2024, the SEC issued a stay of its final climate-related disclosure rules. And this stay is in effect pending completion of the judicial review that is ongoing right now. There was a ton of litigation filed challenging these rules as soon as they were issued, like the day and the day after they were issued. So the SEC issued this stay because they said it will allow the court to focus on a review of the substance of the rules rather than fight over a court-issued stay, whether the court should issue a stay or not, as requested by some of the petitioners here in the litigation. And this stay, it's important to talk about why the stay was issued. The stay follows a flurry of litigation, as I mentioned, right after the rules were issued on March 6th. Several private entities and trade groups and states filed petitions in many circuit courts of appeal. And in total, there were 9 petitions filed in 6 circuit courts of appeal across the nation. On March 15th, so that's just 9 days after the rules were issued, the U.S. Court of Appeals for the Fifth Circuit granted a motion seeking an administrative stay of the rules. So the rules were previously in March, and I'm working backwards here, stayed. So just 9 days after the rules were issued, they were administratively stayed by the court. But then there was, this is some fun facts about federal litigation, I suppose. On March 21st, the judicial panel on the multi-district litigation selected by lottery that the U.S. Court of Appeals for the Eighth Circuit would be the venue hearing the case comprising all of the consolidated lawsuits. So all of those petitions that I mentioned that were filed in 6 courts of appeals will be heard jointly together in the Eighth Circuit. And the next day, the Fifth Circuit resolved its administrative stay. And that's what led us to the SEC deciding itself to stay its rules nonetheless, because several petitioners filed motions with the Eighth Circuit, again, seeking a stay. So the SEC came in and said, we don't need to fight over whether or not the rules should be stayed. Let's talk about the substance of the rules. We will stay the rules. So that's where we are. The rules are not in effect. They are going to be working their way through the courts, and that could take quite a bit of time. And we do expect there to be an appeal to the Supreme Court. So the fate of the SEC's climate disclosure rules will likely be decided by the Supreme Court. I don't have a great guess as to time, but probably not super soon, and we take up to a year for that to happen. So that's where we're at.
One question I'd be curious about, and if you don't have the answer to this, that makes perfect sense. But my understanding is that I think the SEC rules weren't supposed to, even if they did take effect in March 2024, that they wouldn't apply to companies until their disclosures for 2025. Is that right?
Yep. That's exactly right. They wouldn't go into effect until 2026, really.
Yeah, until 2026. So is the thought that, say the Supreme Court hears this in, let's say the end of 2025, I doubt, say the Supreme Court upholds, even that sounds like a far cry, but let's say that the Supreme Court upholds.
I try not to go into that narrative.
Yeah, I know.
Let's just keep it positive.
I don't want to go into the makeup of the court or anything like that.
But the fate rests in their hands.
Let's say they uphold it in 2025. We would assume that they wouldn't be effective as of 2026, probably not till 2027, perhaps.
Yeah, we would expect that's exactly right. So what typically happens in these sorts of situations when there's a stay and a legal fight, the initial deadlines laid out in the regulations and the final rules would likely be amended or extended by the SEC. I mean, they would not, the agency, based on past experience, we would expect, I'm making some assumptions here, but let's make the assumption, we would expect the agency, based on past experience, and other federal agencies do this as well, would extend the deadlines to more reflect the initial intent of the rules as they were initially plan to go into effect. So I would expect if the litigation takes a year, and then these rules do go into effect, we would probably have another year built into the timeline that the SEC would amend to allow companies time for compliance. But I think the question you're getting to is, when should companies start working towards compliance, start preparing for compliance? And that's a really tough, I don't have a great answer for that, because some companies, depending on the size of the company, how sophisticated the company is, some companies have already been working towards compliance. And I would encourage those companies to continue their efforts. It will not be a wasted effort, even if these rules don't go into effect. And I'll talk about California's requirements and how those overlap in just a few minutes. And look, climate disclosures are here to stay, or so it seems, at least in California. So doing your initial calculation of your emissions, your scope 1, scope 2, and even scope 3, although scope 3 emissions are not required under the SEC rule, which I can talk about in a second. But doing those initial calculations, potentially engaging a consultant to help you assess your emissions. And then at that point, once you have the calculation, you can consider creating emissions reduction targets. You're not required to do so under the rules, but it is something that many companies are voluntarily doing already. And so for many large companies, it's part of their benchmarking, keeping pace with their peers. If their major peers are doing this, like think of the major tech companies, think of Google, Meta, Apple, and others. Those companies release emissions reports already. They have emissions reductions targets already. If you are one of their peers, you are probably already doing that too. Other smaller companies may not have the resources to do so yet, so maybe they're starting smaller. And there are exceptions in the SEC's rules for smaller companies, and the rules only apply to public companies to begin with. So there may be less that non-public and smaller companies are doing. But for the biggest companies, the public companies, it does make sense to continue formalizing the processes for accounting for and setting emission calculations and targets and goals.
And not only for the purposes of different regulatory constraints, but also because it allows companies. I've talked to a lot of lawyers who are in the European space and have been advising companies on European disclosure laws and different regulations. And they found that once the companies dig into this information, they find a lot of areas where they can trim fat. So it's where they can reduce costs or find ways where it's relatively easy or straightforward for them to reduce emissions. So once they do undertake the process, they get a lot of clarity as to what they could be doing. Let's shift gear. Let's talk a bit now about the California specific disclosure laws and how they relate with the SEC rules.
Yeah, absolutely. So if you don't mind, if I could just stick with the SEC rules for just a moment, and then I'll shift to California just so I can describe emissions disclosure obligations under the federal rules and then compare them. And I also have I want to set a little bit of a broader context on why emission disclosure matters, right? We're talking about, I found that interesting because I've given a lot of thought to it. You know, what's the big deal and why is the government requiring emissions disclosures, but they're not requiring emissions reductions? Like, why? What are we doing here? And what you just said is part of the big reason. So let me start there. So again, what's the big deal here, and why is the government, in this case, the Securities and Exchange Commission, issuing rules requiring climate disclosure? Side note that I won't go into, the reason that the EPA, the Environmental Protection Agency and the key environmental regulator for the country, is not issuing these rules is because the EPA in part got shut down during the West Virginia versus EPA case. I believe it was last year, and the court found that EPA could not regulate emissions in one specific instance. So many commentators believe that that's why the SEC is going forth, and SEC has been working on these rules, by the way, for years. The proposed rules were issued 2 years ago, but the SEC here has some better footing for the disclosure piece for public companies alone. So the SEC has continued on. So let me take a step back. So there's a general consensus that the impacts of climate change pose a serious risk to the overarching U.S. financial system and to public companies and private companies as well, which we'll talk about within the California rules. So for example, one study found that the average business could experience losses of approximately 45 cents to every dollar of cumulative operating cash generated from their ongoing business activities between now and 2050 due to the impact of global rising temperatures. So consider physical impacts to, flooding of your business, just as one example of the many impacts that could impact companies. Climate-exposed industries such as agriculture, construction, manufacturing, and tourism, those are the top four, are particularly vulnerable, and there may be others as well. And then those climate-related risks, as I just alluded to, include both physical risks and transition risks. The physical risks are the actual risks to your business, such as damaged infrastructure or the electricity systems that power your business. This could be due to severe weather events, wildfires, floods, etc. That's just one example. Also, transition risks, which is a shift in investment values, and this could change due to underlying shifts in energy and climate policy or consumer demand. So one example is that investors shift their investment dollars out of real estate on the coast, and this could have a bigger shift in the broader investment market. So there are a lot of different factors here. We can't predict all of them, but the bottom line is that climate-related risks can result in real financial risk for businesses and investors. So that's why the SEC is focused on this. And more broadly, it's not just the SEC, it's other agencies as well, including California. And to date, as I mentioned, many companies have set net zero goals and other greenhouse gas emissions reduction targets. And that's great, that's voluntary, but the reporting on these goals is not standardized. So that's why the SEC stepped in here, because the current reporting is too fragmented and too inconsistent to be useful to the public and investors. And then looking at this from an environmental or climate perspective, for those of you who are also environmental lawyers out there and don't just want to talk about disclosure, but you want to talk about change, why does the disclosure of emissions matter? So the SEC rules and the California rules right now are not action forcing. They require disclosure only. The SEC is not mandating that companies reduce their greenhouse gas emissions. That would not be permitted, most agree, under the SEC's implementing statute, authorizing statute. So disclosure, though, alone is significant for the reason you pointed out, Patrick. So if companies can count, and they're required to report, they start paying more attention. And there are several different studies that show it leads to change, because companies, I guess for lack of a better word, may get embarrassed that suddenly there's this giant number out there associated with their emissions, and their peers are doing much better if they're all required to report in a standardized way. So the bottom line is that there's evidence to show that public disclosure can lead to improvements in performance. And standardized disclosure would mean that the public, especially in California, companies will be required to publicly post their emissions disclosure information. Consumers, shareholders, and others can see information, compare. And according to a study, emissions are generally viewed by stakeholders, especially those in financial markets, as a negative attribute for companies. So this is important information for investors, again, and that's why the SEC is involved. And then, basically, if you cannot manage what you can't measure, so if you start measuring your carbon emissions, you meaning company, can consider reducing them, and the public disclosure again puts pressure on you to do so. You don't want a bad public score if all of your peer companies are required to report too. So this is a big first step. So I thought that background, I've been thinking about it a lot, and I hope that background is somewhat helpful, because it is not action forcing. And I think that's really important. The SEC is not regulating climate. The SEC is regulating climate disclosures. But someday we could hopefully have an environmental agency regulating climate. That's my 2 cents. So going back to the actual rules themselves, Patrick, the SEC rules, the final rules, require emissions disclosure for scopes 1 and scopes 2 emissions only. Scope 1 emissions are direct greenhouse gas emissions from operations that a company owns or controls. And then scope 2 are indirect from purchased electricity, for example. That's the number 1 example. So those are, if you have an office building, I think of, the law firms out there, the law firms scope 2 emissions are those created to generate the electricity we use in our buildings. So think of, for example, on the one end of the spectrum, emissions associated with the generation of coal-powered energy. Those emissions are going to be much higher than, say, solar energy production, which generally has no emissions associated. So that also explains why companies want to shift to renewable energy such as wind or solar, because the scope 2 emissions are much lower, and that overall makes the company's emissions score, to simplify it, look better. So it's important to note that scope 1 and scope 2 emissions under the SEC rules are only required to be disclosed if they are material, and it's the traditional standard of materiality that's defined by the Commission and in Supreme Court case law. And only large accelerated filers and accelerated filers must disclose those scope 1 and scope 2 emissions. And that's a change from the proposed rules. The proposed rules required all registrants to disclose, and they also require disclosure of scope 3 emissions. So the SEC has pared back the rules quite a bit. And again, the SEC's rules apply to public companies or companies that are going to IPO. Shifting to California, California is a bit different and takes a broader approach. There's some overlap, but then there's also actually some significant differences. So California in October 2023, the Governor Newsom here signed into law 2 climate-related disclosure bills. The first looks really similar to the SEC's rules, and that's SB 253. It's called the Climate Corporate Data Accountability Act. So this is a law requiring disclosure of emissions, so very similar to SEC's rules. This law applies to all companies, private and public, that do business in the state of California and with total annual revenue exceeding $1 billion. And that's $1 billion total. So this, not $1 billion in California, $1 billion total. So this does cover quite a few of the major companies you think of, like the household names. This law does require scopes 1, scopes 2, and scopes 3 emissions. So it's more broad, again, not only in scope, but in requirements in the SEC's rules. And so, you know, this is a big deal because
we should note it's also being challenged by the typical players you'd expect, right?
Exactly. Yeah, I was just going to say this law is a big deal, but it's also being held up in court. Of course, it's actually not being held up, though. It has not been stayed. So the distinction is that this law is in effect as of January, although the required disclosures don't start for a few years. But look, it's a big deal because the SB 253 in California was the first time in the country that there are legally required, not just voluntary, emissions disclosure obligations. So, I mean, I think it was a big moment, right, in October 2023 when California, not surprisingly, was the state that passed the first climate disclosure law, because it is, I think, like a foreshadowing of what's to come. I'm not sure how climate disclosure will be required nationwide. It might not be the SEC's rules if they don't go into law. But I think it is a harbinger of things to come that, you know, there is a push from many sides for companies to disclose their carbon emissions for all the reasons that I went into a few minutes ago. But there's a push from the public, consumers, as well as shareholders, stakeholders, and the government. I mean, the government wants this information and helps the government account for the state's emissions as well.
And the interesting thing about these laws, you mentioned that the SB 253 only applies to larger entities, and of course the SEC rules only apply to large publicly listed entities. But the thing is, and particularly in the California context, when there's scope 3 targets or scope 3 requirements, is that this will percolate throughout the supply chain because they're going to be asking these smaller companies to give them reporting. So these smaller companies are then going to say, well, if I start reporting that I'm actually using a coal-fired plant rather than a solar plant, perhaps I should switch to a solar plant so that way I'm reporting better. Or they might say, well, the person that I'm reporting to doesn't care, so I'm not going to care. But that's going to be something, a mechanism so that this ripples throughout the economy.
Exactly. Yeah, I was just going to go into that. I realized I skipped over what scope 3 emissions are for those of us who aren't so familiar with the terminology, but scope 3 emissions are supply chain emissions. So for many companies, they consider travel, for example, to be scope 3 emissions. If you're doing company travel and you get on a plane, the emissions associated with that airplane would go into your scope 3 emissions calculations. Or suppliers, I mean, as a law firm, we are being asked to calculate our emissions for our clients because we are their supplier and we make up their scope 3 emissions. So it is a big deal. I mean, we've been getting surveys as a law firm, surveys requesting information on our emissions for several years now. And we've noticed it's becoming more and more common. And we're not alone, right? It's not that companies are just suddenly asking law firms for their scope 3 emissions. They're asking, or for the law firm's emissions, which are the company's scope 3 emissions. But more and more companies are doing this broadly across their supply chain. They're trying to calculate their total emissions diet. So, and it's a big deal because you're right. When we as a law firm calculate our scope 3 emissions, we may be asking our suppliers and vendors who are small companies, local companies, to figure out what their scope 1 emissions are so we can add that to our scope 3. So there is this ripple down effect. And again, the ball's already rolling because the bigger companies are already doing this. And they're asking us, the service providers as law firms, and their suppliers to calculate our emissions. We're starting to do it. And we're having, my firm's been calculating our emissions for several years now, and we are considering reduction targets, and you can see the effect it has, right? Like you calculate first, and then within a year or two, once you feel comfortable with your numbers, you consider setting reductions targets. And it has this, what I view personally as a positive impact on the overall ecosystem of emitters.
Yeah.
So I think
no, I mean, you mentioned the key phrase, you can't manage what you can't measure. And it's a testament to the fact of the new wave of, let's call them ESG laws or responsible business laws or whatever regulations or rules that are in place to ensure that companies take account of the impact on environment and society larger than simply financial impact. The first generation, I often say, is the CSR regime, where it was all voluntary. Now you're being led by the investment community, and that's why you have ESG rules coming out of the SEC, because those are representing investors, for instance. And you have consumer related laws as well. And the point is, there's an evolution of how seriously companies need to take the effects of their social and environmental impacts. And I think now we're at a stage where they're incorporating it into their business model, they're incorporating it into their best practices, so they're more likely to take it much more seriously. Yeah.
Exactly. And that's I appreciate you mentioning CSR, corporate social responsibility, because that is sort of the forebear or big brother of the ESG movement. And CSR was essentially a marketing tool. I mean, companies that prepare CSR reports would not call them marketing tools, but companies did that really to keep pace with each other. There were some truly do-gooders who wanted to report on their social impact, and that is also oftentimes it also reports on their human rights and global impact and supply chain. And then ESG also looks very closely at the S is social, but that social often looks inward at employment and diversity practices.
Things like that. Yeah, how they treat their internal stakeholders rather than their supply chain. Yeah, and and you can say that. Important. Yeah, and because ESG is focused on the investment community, it's a bit more rigorous, it's more quantitative, it has to be a bit more verifiable. We were getting to that place in the context of, say, for instance, the greenwashing litigation, where there'd be CSR statements, the constituency would be the consumer, and slowly but surely consumers were holding companies who were advertising to account if they couldn't validate their CSR statements. And so similarly, you have the investment community that needs to hold companies to account when they're making material financial disclosure. So
yeah, the SEC speaks to that as well. And I'm glad you brought up greenwashing. Yeah, the SEC says that there is a benefit of disclosing emissions in a required standardized way. And they specifically stated that mandatory disclosure of scope 1 and scope 2 emissions data in commission filing, again, public companies here, but it extends more broadly than public companies. The virtues here is that it may deter potential greenwashing that could occur with voluntary disclosures. That's because these disclosures are required under federal law or state law, subject to agency oversight. And so companies have to ensure that they're reporting their emissions accurately. This isn't just nice to have. This is mandatory, and the SEC is going to review it.
It's not fluff coming out of the marketing department that hasn't been properly validated. This is going to the investment community, so you're going to ensure that I mean, not to toot our own home, but you're going to ensure that you're going to have
Exactly.
lawyers looking over this and saying, why are you making that statement? What information can you show to demonstrate that statement? I was talking to another lawyer the other day. Our role isn't to ensure that the information is accurate in and of itself, because we can't do that. We're not going to go on the ground and actually take the measurement. But we can ensure is that systems are
Exactly.
in place to ensure the information is accurate, that it's stress tested, validated. And that's our role. And I think that's
The
what we're good.
processes.
And
Exactly.
and your, for instance, your background in environmental law, it gives you a strong leg up in the context of understanding a lot of the salient issues when it comes to disclosure. I wonder if we could talk about that a little bit, how your background in environmental laws and environmental rules allows you to stress test some types of disclosures in a more proficient manner.
Yeah, of course, Patrick. Yeah, that's a great question. And I'm trying to think of a quick example of a way I can give you that. I mean, let's stick with the greenwashing example for a minute. So there are not, just thinking about how to stress test this, but there are not regulations that state if you call your product green or clean or eco, here are the regulations that state how you define that term. There are no regulations that state that, right? But in tying back with, but if a company does say something is green or clean or eco, I'm just using some of the common terms on, say, cleaning products, manufacturers, bottles, and not to call out that industry, but just as an easy example. So a way to stress test that would be to think about what does it mean if something is greener or cleaner or better for the environment than traditional cleaning products? And what we think of in, when you use cleaning products, they're often going to end up in the waterways. Like you're going to flush them through your sink. You're going to, rinse your sponge off that you've used the cleaning product, and it's going to end up in some sort of water piping system. It's not necessarily going to our drinking water. What you pour down your sink doesn't go straight to the drinking water, certainly, thank goodness. But it will be part of the water system, and it will need to be treated to be recycled. So in terms of thinking about it from a traditional environmental lens, the Clean Water Act regulates discharges of pollutants to water bodies, right? So if you're arguing that, or you're not arguing, you are asserting that your product is green, what I think of, and the way I would pressure test that is, could elements in your product or ingredients in your product be considered pollutants under the Clean Water Act, as that term is defined? That would be one way to pressure test. And it's not the only way, but that would be one way to pressure test whether something is actually green. For example, are constituents or elements or ingredients of your product actually biodegradable, meaning they could be discharged to the environment as opposed to needed to be treated? That to me would be a way to pressure test green and clean versus, bleach, if we're comparing to traditional cleaning products. Does that answer your question, Patrick? Should I go into a little more detail about that?
Yeah, no, that was a great example. It just goes to show how our previous backgrounds in other disciplines can be useful when applied to the kind of ESG practices that we're doing now.
Exactly. And I want to highlight, I know we only have a few minutes left. I just want to highlight also the second California law that I think will be important in years to come, and an aspect we haven't spent much time on. But in addition to emissions disclosures, both the SEC rules and California law are requiring broader, I'm just trying to find the term, the financial risk related. Yes, exactly. Thank you. What's the name of the law? I'm sorry, I'm just scrolling through my notes. The Climate Related Financial Risk Act, which is SB 261, and that is
I have no idea. I have no idea the actual name of the law. If you say SB 261,
you got close. I was like, you're so close, yeah. But this law requires. So this is another important element of climate disclosures, right? This is not emissions disclosures, but it is climate-related risks. So those climate-related risks are the physical and transition risks that I already talked about, right? And that's it's less specific than I produce 10 Scope 1 emissions, or I'm making up a number here just for purposes of discussion, but rather this talks about a real qualitative and quantitative assessment of the potential impact of climate on your business. If you're Disney World, how are increased hurricanes going to impact your bottom line if you have to close your park more days a year? So that's one example you would assess. We're seeing increased hurricanes. We're seeing 10 days of hurricanes a year versus 3 days of hurricanes per year. We project going into 2050, making up a year, we're going to see 20 a year. So how is that going to impact our business's bottom line? And that risk should be disclosed and mitigated if possible. So that's the other aspect here.
Yeah, exactly. How is climate change and related issues going to affect your business, and how are our business operations impacting that? Or how might our practices with respect to rainforest deforestation going to affect potential business risk going forward, right? So if community advocacy groups find out about the practices, how might that affect our business as well? So that's a material financial risk that the investors would say they want to know about. What do you see in the next few years?
I did allude on this topic a little bit, and I will just quickly say it again. I think that mandatory climate related disclosures are here for many companies and are coming for others. So I think what the future looks like is, as resources allow, companies should start considering, hiring that third party to assess their greenhouse gas emissions, calculate them, see where they could reduce if they're interested in doing so. They're not required to do so right now, but from an environmental perspective, it probably makes sense to start transitioning over to renewable energy where you can, for example. Could you switch your electricity source to reduce your scope 2 emissions? So at a high level, I think mandatory reporting is coming or here. So getting your processes in place, getting the lawyers to help you get organized, to be able to show your work is what we tell companies. You need to be able to show your work if you're coming up with a number for your emissions disclosures. I think that's a good first step, again, for companies that have the resources to start doing so.
Well, great. Yeah, I like to say the era of ignorance is over in this context. So where we're going next, we'll just have to find out together. So thank you so much for coming on. It's a really fascinating practice group you're involved with, and really great to know other fellow lawyers in this space. So thanks for coming on.
Thanks so much for having me, Patrick. Have a great day.